The riskiest day in your med spa isn't the day you open. It's the day you see your first patient without the right contracts in place. That mistake alone has cost owners tens of thousands of dollars. But there's a step-by-step way to protect yourself before you ever pick up a syringe. I'll walk you through it the same way I do for my own clients. So here's one attorneys usually don't talk about. You're sitting around, your business has grown, you got 100 employees, and then out of the blue, you get an email from attorney, a nastygram, and it says, cease and desist, you are infringing on our trademark. Now, the weird thing about trademarks is that doesn't matter if you didn't know that you were doing it, doesn't matter if you didn't mean to do it. If you use somebody else's name and that's trademarked somewhere else in the United States, that exposes you to liability. And not only does it expose you to liability or having to pay the trademark owner, now you have to completely rebrand your company, which is not fun to do. That means new entities, new contracts, well, just about everything. And that's what happened to one of our clients. And by the way, when I talk about client stories, I do heavily redact stuff so you don't end up in my comments. I just want to make that clear. If you end up working with us, I use these examples to help, but I, of course, change things a little bit just so that no one's being exposed. Client confidentiality is a big thing to me. But what happened here is we were running along, great business, 100 plus employees. We get that nastygram, and now we have to go and hire another attorney to respond to that, talk about payment, rebranding, all of that stuff. That could have been avoided with a 1-minute name check when you file the entity. People fixate on, picking the right name for branding and the entity structure is very important, but they also forget a tiny little detail, which is this name actually trademarked? So that's one that I don't hear many people talking about. Everyone's rushing to get the entity and do it the right way. But I want to make sure that you also understand that you could accidentally infringe on a trademark by picking the wrong brand name. Now, without giving legal advice, because I'm not your attorney and this is a podcast, you're generally safe picking your name and then what you do. So Holt Law, not worried about that being trademarked. My last name and what I do, law, very simple. You're generally okay if you're doing something like that, but you should always do a quick trademark check regardless. Entity formation. So high level, likely an LLC if it exists in your state. The professional type. So for example, in Minnesota, professional limited liability company. In California, that is not allowed. So professional corporation. That's high level, usually the best entity choice, but you should make a conscious choice with the help of a CPA and attorney before you file. That's really the point to get out. Other point is you absolutely need an entity. I don't want to see you doing business as yourself because now we have nearly endless liability to all of our personal assets, all of the things that we've built for ourselves and our family, our car, our house, our savings, our retirement, what have you. The whole point of the entity is to create a shield from all of that. Even if perhaps you do something wrong and there is a lawsuit, it will be, assuming you were doing business activities, it will be shielded and only the business itself would go down with that lawsuit. So extremely important that you actually form an entity. And there is a temptation at the very beginning, and it's very difficult to start signing contracts and start doing things with your personal name, David Holt, as opposed to my entity name, Holt Law, because I just haven't filed that yet, or I'm kind of sorting some things out with my CPA and attorney. Very important that you wait or speed up the entity formation before going out and signing those contracts. Because now if I go sign a lease agreement or I sign any other contract, I am saying that I'm personally liable. And that is the whole point of what we don't want to do by filing an entity itself. Once the foundation is set, the next trap is compliance and medical director agreements. All right, compliance and medical director agreements. In California, absolutely a big deal. And here's why. It's one of the reasons we exist in California is because there are very strict corporate practice of medicine rules, which generally mean you need to make use of a medical director. And in California, currently as it exists, this means that at least 51% of your medical spa or medical clinic needs to be a physician. Now, that doesn't mean that if you're a nurse or another type of practitioner that you're completely out of the game, but it does mean that likely what you're trying to do is engage with a medical director without giving them ownership and control of everything that you're trying to build, right? Because you're the one probably taking on a lot of the risk, building the business, and you're trying to hire them to do a job. Now, why this is important is that there are layers to types of medical directors. And unfortunately, if I go and Google and look up medical director, it can be very confusing as to what's out there, how to engage them, and how much to pay them. So where it's really good and where we have a lot of clients asking questions, we get people contacting every day and they're just asking very specific medical director agreement questions is, how much do we pay them? What do they do? And do we need to give them ownership or not in California? Now, there's a lot of ways that we can structure that, but I'm going to focus on the medical director agreement itself, because at the end of the day, it's the physician or medical director that's ultimately responsible for everything that they delegate down. Just like me as a lawyer and owner at my law firm, if a legal assistant or a paralegal does something wrong, I'm ultimately responsible, or my malpractice, my liability. It's the same generally for the medical director. So, we're going out, we're doing Botox, microneedling, plastic surgery, what have you in California. And, we might have some pretty risky procedures. What we want to have is terms in place that say who's responsible for what. Because if you don't have that and it's vague and we haven't properly said who gets paid for what and who's responsible, what happens is we don't have accountability for a lot of the gaps. And then lo and behold, there's a patient complaint. There's, a nasty lawyer demand letter. The board is investigating and everyone's pointing the fingers internally. Whereas if we just had a medical director agreement and we wrote down who's responsible for what, we would know exactly who is supposed to do it. Now, compliance isn't optional. HIPAA, OSHA, infection control, all of these are laws that you have to comply with that we just think in the background somebody else is doing. That's usually not the case. Somebody needs to take responsibility. The medical director agreement plus associated agreements say, all right, here's who's in charge of what. It may not necessarily be the medical director. Really depends on if they're an owner or not. But at the end of the day, it's the written policies that protect you from the staff mistakes. So with the compliance and directors in place, the final step is the actual contracts, the guardrails for growth. All right, so picture this. You just purchased this beautiful laser device that you're doing on your patients, making their skin glow, and you're making money, patients are happy, and out of the blue, 6 months in, the laser stops working. It stops firing, won't turn on, and you go back and you call the sales rep who doesn't answer the phone, and you call the company that you bought the laser machine from, and you're trying to figure out how to get it fixed quick because you're losing money. You can't do the laser procedure anymore. Turns out, buried in the financing agreement and the contract you signed to have that laser that you don't even own yet, it says, well, if it breaks for X, Y, and Z, you have to pay for one of our technicians to come out and fix it. That is not included. There was a upsell that you missed or some sort of insurance thing that you missed, and you're on the hook. And unfortunately, now you have a broken laser machine and a bad contract that you sign. So that's an example that I've seen firsthand of how out of the gate, not having a solid contract actually almost derailed a business. Now, in that situation, we were able to get it resolved, but that was outside of something that a good contract being signed would do. We had to resort to a lawsuit. This can happen to any medical spa, medical practice, really any business, but especially in healthcare, there are all sorts of contracts that you can sign in your first year that are not a good idea, or at least provisions in those contracts that are not good. So hiring employees right out of the gate. So for employees, we got to think about things like not just the pay structure, but also paid time off, benefits, how those are earned, how those are accrued. Really, the compensation structure is the biggest thing I see in employment contracts. Usually there's a combination of some sort of legal fee splitting that's mixed with hourly or maybe a salary. There's a lot of options. On the other hand, vendor contracts. So you're getting involved in a cool EHR software and you sign this big contract. It seems to be working well. Things don't work out or you're transitioning to another one. And it turns out that there's a really expensive breakup clause. So in order just to get out of the contract, you have to pay all this money, even though you don't want to use it or you're not even using it anymore. We already talked about lease agreements. Signing a restrictive lease agreement that's worth more than your house when you add monthly and yearly, the term of the lease, one little provision, one bad provision in there can be the difference between the business surviving in the first year and going under. And then finally, another type of form or contract is patient consents. Really easy. Usually I see clients and they grabbed one from a friend or they got it on Facebook or they just, threw it through AI. Having that dialed in and reviewed by an attorney could be the difference between a patient complaint that turns into a career-ending lawsuit versus one where you have a viable defense. So that's absolutely one that you can't skim on your first year. If we're talking about growth and we're talking about working with investors, banks, and partners, these are contracts where there are some very sophisticated business people out there. And for banks, you got to have all of your ducks in a row. These are absolutely contracts that need some sort of legal review. On this episode, with these 3 steps, your Medspa isn't just compliant, it's built to scale with confidence. Now you've got the roadmap for opening a Medspa. But if you're looking at other healthcare models, the next episode breaks down how the MSO or Management Services Organization structure can help you scale even further.